but I don't think I should give a formal speech here because the students are from which year, but they are first year, second year. So there are 3 years course or 5 years course? 3 years course. Okay, okay. So instead of telling you what happened in a Golaknath or what happened in a Keshwar and Bharati, there is no point. Or how and now in the age of this internet and digital era, you know everything. So I don't want to give a formal speech. That may not be desirable looking to the. Otherwise also I prefer interacting with the student. That is better because telling you something, just reading a speech may not be, you may not understand. That may not create some sort of interest in you. So, because I am in the judiciary, so we have to hold our workshops. Whenever I go for a workshop and other judicial officers, I ask questions to them, and same will I do with all of you. So you have to answer. So you can ask any questions if there is some the language is go by. You can ask in any language. So now who will start asking question now? That is what first question I will ask you, and then you can ask other questions. Now we are ready to preamble. we are ready to preamble. Now, what do you understand by justice, or what do you mean by justice? You have one microphone. Can it be removed? Or you can't remove this? Okay. All right. Okay. So, please tell me what do you understand by justice, or what do you mean by justice? So, who will tell me? The first year student should tell me what is justice.
Anybody raise your hand and answer.
And stand up.
And stand up and answer. Yes.
Anybody?
No one? Yeah. Stand up.
Justice for me means to get relief from any wrongdoing or any suffering that I had from anyone.
Okay.
From boys?
People are treated same, no favorism. That is called justice.
That is
Called the justice. There should be no favorism. All are equal.
no favoritism. That is justice.
Yeah.
Okay. If I say
So,
no.
bring to peace in a society is a justice. From my side, bring to peace in a society, that is a justice.
If I say that whatever the court decides in accordance with law, will that be a justice according to you? Or will that be a justice according to the constitution? Yes. Normally, justice will refer to the judiciary, that the court. So, will it be a justice only? Justice is restricted to judiciary only. Huh? It is not restricted to the judiciary. If a judiciary decides something in some accordance with some law, then will it be a justice only, or that there is something else which we can call justice? All right, your faculty wants to answer.
Sir, in our everyday life, we are into a lot of interactions, and it is our duty, ethical, we can say, or a moral duty, that we do the right. And I think when each one is conscious enough and does the right, I think no wrong is done. And I think because of that, each one is serving justice at their own level. I believe that the grassroots of justice is a civil society per se.
We'll go by one by one, because now why there is no but I don't know whether Constitution, we have. Anybody is aware about Article 142?
Yes.
Anybody is aware?
Yes.
Article 142. The students, Article 142. Have you read about Article 142? Oh. I will tell you what Article 142 is. The Article 142, the empowers the Supreme Court to do complete justice. So why that article is there in the Constitution? Why that article is that 142 article is there to do complete justice? Is there any need of ultimately the court decides in accordance with law? If there is a law, if there is a right, there is a remedy. If the right is violated, you have a remedy to approach the court, and that right you can assert before the court, and the court decides whether you were entitled to relief on the basis of that right. Then still why that Article 142 is there? Where in what situation that Article 142 operates? If the court decides on the basis of from district judiciary to high court, high court doesn't have that power of to do as there is no article which empowers the high court to complete justice. It's only Supreme Court under Article 142. Why that? What was the need of that article?
That is the final binding justice which is provided, which cannot be appealed. So even if injustice is provided or injustice is done at the lower courts, then the high court, then the one who is the supreme that has the power to find the law.
Can you visualize any situation where you feel that this is the law is like this, or there is no law, but still injustice is caused to him, and that is to be remedied? Can you visualize that situation?
If we can see the landmark judgment of Supreme Court, that is the guidelines were provided by the Supreme Court itself. It was of the cause that the lower courts do not have that ambit to go over that and implement in such a way. So Supreme Court had the ultimate power in hand to go forward between binding conditions.
Dhaka is really a good judgment because of that.
Saying woman empowerment and saying woman as a woman, wherein nowadays women are coming up as an employer, wherein previous in history you can see women are not getting that kind of.
Right, because there was no legislation in relation to this harassment at workplace, and then after guidelines, now this act has come. There are situations where there are really unique provisions in your constitution. Unique provisions, but sometimes while serving as a judge, we do feel that the law is against him, but we do feel that some injustice has been done to the person concerned. That needs to be remedied. It's not that what we do in accordance with law is the only justice. Or just because some law is like this and therefore we have to go by that. There can be situations where we feel that the law is this, but still this is some injustice is done to this litigant or something.
And I would just like to say a few words about this, that about the point that he has discussed, that sometimes the law does not define it, but the essence is added by the judge. And this you will usually see in everyday, time. In courtroom number 27, wherein you see the bail applications and the ADA applications. I'm very thankful, sir. I'm very thankful. Very good.
So you won the case Munna versus NCD case.
Yes.
So,
Yes.
Stand up.
Stand up.
That's all right.
Ask questions, guys.
So you won the case of Munna
Alright,
versus
yes,
even the
please.
case where
Loudly.
Munna versus NCD, or Municipal Corporation of Delhi, the child got hurt and the compensation was given.
Please a little louder. Take this microphone. Okay, give it.
Am I audible?
Yes,
Yeah, even the case of Munna versus NCD, where compensation was given to child, that case. So the justice was fairly given in that case. If you could shine a light on that.
What is your question?
I would like to know more about that case, like how the justice gets defined in that, and also there's another case where a policeman was electrocuted.
It's very specific. It's very specific.
Any question about judiciary that
that case something happened in there due to negligence the hurt was caused, and in that case judgment was provided. Then it was given compensation. It's 2024 case. It was there in the study now. But once you make sure you are asking something which is landmark judgment which he will be able to, not the specific one. You can tell from your end some specific cases wherein he will tell whether the judgment was given was correct or according to his perspective, but not the one which are not the landmark cases.
Now we have a very now. So what do you think about Sabarimala Judgment? Are you aware about Sabarimala Judgment?
Yes.
You are aware about Sabarimala
Yes.
Judgment? Okay, what do you think about that? We are in a college, so we can discuss it. If you whether you read it. It's a really discrimination. Some girl student might first answer this question.
Sir, if we talk about that particular
Stand up.
Sorry, sir. If we talk about that particular case, Sabarimala case, that the woman's rights were talked about, but if we see on the other hand, there is one temple in I think West Bengal, Nepal side, Kamakya temple, and Assam. So I heard that in that particular temple, during particular period of the year, men are not allowed. So why men are not protesting for their rights and why women are? I think you got my point. No.
one person start passing the mic. Anybody wants to answer this? Please give the mic.
Sir, in the Sabarimala case, the case was of the exclusion of women. How can you say exclusion of women is right? In the temple. And it was a specific age from 10 to 50. You're saying it's right. Because in another case in Assam, men were not allowed. So did we ask men to not stand up for their rights?
He is not justifying. He is not saying. He said that we are also discriminated.
Yes,
Which we have put forward, sir.
Yes.
So you think that is the correct judgment. That is what.
Yes.
So why the people are so much criticizing it? Even the local women there are protesting against that judgment. Why that is happening?
So because it's
Where we are at, why that is happening?
yes, so it's been going on since centuries. Women are suppressed in century and now the aggression is coming up, is what I feel. Not aggression. That, I think that depends on the upbringing of the family. Some families are very traditionally rooted, right? So if you grow up in a household where you're told that you cannot enter somewhere because of who you are, you cannot just abandon those values that you were said that were right since a very small age. because they feel that non-religious people or the state isn't getting involved in their worship.
Okay, so do you feel it's a diversity? It's not a discrimination, but it's a diversity.
Yes.
Do you think it's a diversity or do you think it's a discrimination?
Hello. There is Juvenile Act 2000. I wanted to ask one doubt, sir. Juvenile Act 2000, and there is a Juvenile Act 2015. When in the Nirbhaya case, the boy, 16 and a half years of age, was not punished because of he was a minor age, below 18. But in 2015, it has the law has been changed, the amendment has come. So the provision was given, he should be dealt with the adult person. But during that, sir, till today and till now, he should not be punished, death punishment, and as well as he should not be given life imprisonment. These 2 points are also not there. That is my doubt, sir.
The problem is that even in a new act, if you want to try juvenile as an LLB, then you have to conduct inquiry. If it is in that age of 16 to 18 years, you have to conduct inquiry. And after conducting inquiry, if court comes to the conclusion that he was conscious of the fact that what he was doing, then only you can try him as an adult. Otherwise, he was not aware of the consequences of what he was doing, then you can't try him as an adult. So that is the, now that way the law is. So unless that inquiry is conducted, unless it is found that he was aware of the consequences, unless that conclusion is reached, you can't try him as an adult. And ultimately, it's all beneficial legislation. And so we want to protect our children. Unless they are aware what they are doing is wrong, you can't punish them as an adult. The whole intent of that legislation is to protect our children. Sometimes we come across so many cases where they are, because they commit crimes because of some compelling circumstances, not because they want to commit that crime. So that is the intent. That is the intent behind it. Now, some unfortunate incidents like Nirbhaya, but still, because of that one solitary incident, you can't just change the law. So you have to think of your. If he is really conscious of what he was doing, and still they have made provisions. If it is in that age group of 16 to 18, still you can try him as an adult, but not otherwise. Therefore, that provision is that. Yes.
Sir, the major concern these days in our country is the air quality.
The major concern in our country these days is the air quality index. So I feel the only transaction between a citizen and government is we pay their taxes, they give us services. So citizens are paying their taxes, but the government itself is unable to give quality water, the better quality of air to the citizens. Then how a justice can be served here and who to be punished?
Now you take the example of Delhi. The problem is somewhere else. Supreme Court has banned the crack list. That will not. But the people are registering.
So,
They are flouting that order.
but also the jungles are being cut down. One in Hyderabad and the second one is happening in Nashik, right?
Huh?
The jungles are also being cut down. So in Hyderabad there was one jungle. Deforestation is also happening, right?
But who are responsible for this? We are responsible for this.
Sir, but the deforestation which happened in Hyderabad, it was a reserve forest, and it was then given to Adani for the excavation of mining project. And the Kumbh Mela is happening in like few days, I guess. So the deforestation will also happen in Nashik. So they are going to cut down 1700 trees. So there is a protest going on for that.
But there was a recent judgment by Supreme Court that mining will not be allowed in jungle areas. So they have stopped that.
Yeah, but the damage is already done.
No, the Hyderabad is still not started because of this.
But excavation has been done there.
Yes, Supreme Court just had announced this order. That is why it also stopped in Nagpur Karba area.
I'm talking about Hyderabad area.
Yeah, Hyderabad didn't stop the protest, so it did stop. It got a wall.
Yeah, but if the damage is already done and the justice is being delayed, so it is also an injustice, right?
You are asking some question on
Environmental laws, so he needs to say that though the damages are done, there is a delay in justice. In the Hyderabad,
to delay justice or what context is saying.
So in Hyderabad, so she is saying that Supreme Court has given the order to stop the mining, right? But in Hyderabad, the trees were already cut down. So they will not cut the trees now, but the trees which were...
There are many examples. There are many examples like this, and sometimes we are dependent for execution of the order. We are dependent upon the executive, and the problem is sometimes they don't take it seriously. So you see what is happening in the bulldozer justice case. And in spite of that orders, all sorts of contempt petitions are filed there. So this is all sometimes we are helpless. They say if an executive says that we don't want to follow court's orders, then court is helpless. Court is helpless. You can't do anything. You don't have any mechanism. Judiciary doesn't have any mechanism to get its order executed. The judiciary is dependent upon the executive for all this. And if executive is still, that is after the orders are passed and still the executive is not that serious in implementing those orders, you can't help it. You can't help it. We have this system. We have this system. What is the and only the contempt jurisdiction not implemented or breached, the contempt jurisdiction can be invoked. That will not, the litigant will not get for contempt, but you will ultimately whatever he has suffered, you can't just remedy that. Or you may some way you may, but this is the framework of our. We can't help it sometimes. And these are the recent the bulldozer case is really no law provides for action like this. No law provides for action like this. But still there and one man commits that crime and the whole family suffers. Whole family suffers. So we can't help sometimes with that. We have our own limitations. So that nothing can be done. Some questions are
just adding to what he was saying, I mean, on 27 November, the Supreme Court actually accepted the elevation definition for Aravali Hills also, where 90, yeah, so 100 meter, above 100 meter they cannot do mining, but below 100 meter they can. And 90% of the Aravali Hills fall in the below 100 meter category, and the elevation definition is accepted by the Supreme Court. So, what's your view on that also?
Because I have not made that judgment, so I may not be that I may not be able to answer you exactly. After madam or sir has read that judgment, they can reply to you. So I read about that judgment, but frankly speaking, I have not read that judgment, so I may not be that proper for me to comment on it.
Good morning, sir. So, few minutes back we were discussing about justice, and what I understand and what every time it holds that a due procedure established by law is considered to be a justice. So, in that sense, justice is very much static in nature. But as far as the society is concerned, we see it is very dynamic and continuously evolving. So, in that context, I would like to ask. So, we can see the flourishing of adolescent love is there, and at the very same time, the existence of POSCO Act is there. So the both come into conflict. So sir, how do you interpret that? So would like to read, know your comment on that.
Now we don't have a due procedure. We have a procedure established. That is the article 21. Due procedure is there in American Constitution. As regards this question, it's really because you have a recent case here in a city civil court where the accused was charged for this POSCO offense. They were in love relationship. Later on, they got married. They were blessed with girl child. The trial was conducted, and because maybe that a girl was very honest, so she said that yes, whatever this has happened, she deposed accordingly. The court convicted that accused for 5 years because it was a technical offense. She was below that age of 18 years on the date on which that alleged incident took place. So, I am also not able to understand the logic behind it and why this age is reduced. Before POSCO enactment, in a old 376 IPC, the age was 16 years. If she is above 16 and the relations were consensual, then it was no offense under 376. Now in a POSCO case, that is now very 18. Many judges are questioning this. There are many judgments the court has observed that this is not right. But the legislature in its wisdom has thought that we should not allow this before 18. So till that law is there, nobody can help. Nobody can dig. And I was really surprised when that man was convicted. I was really surprised. 5 years is not a small punishment. You are ruining that entire family. All relations were consensual. They were in love relationship. They got married. It's not that way. For some reason at that point of time, and I will tell you that this, it's not that some. In every case, the victim goes to the police station. There are multiple cases wherein, because of this consensual relationship, if the victim becomes pregnant, she is taken to the hospital. The doctors ask her age. If she is below 18 years of age, then the doctors the police authorities are informed about that. And though victim is not willing to lodge report, then still, because that is an offence, the crime is registered. So this is the situation, but we can't help it. The court can help it when it comes to the court. Some way out, some sort of. But still, there are instances like the person who married to that a victim, blessed with child. Still, the court sometimes that is surprising that 5 years punishment. So till that law is there, we can't help it and we can't do it. The judiciary, the court may help it when it comes to the, but if such instances are there, then all difficult situation.
Sir, I would just like to add on this point, since we discussed in regards to plenary powers under Article number 142 of the Constitution of India. Back, I think on 28th of October 2025, there was a judgment delivered by Justice Borkar, wherein it was a POSCO case and he was being convicted for 10 years rigorous imprisonment and 5 years for 376 and 363 of the IPC. In paragraph number 9, there was an observation made wherein it was being said that the crime arises out of the love and not the lust, and therefore, considering the exceptional circumstances, since the victim is having a peaceful marital relation with the accused and is having an 8-month-old child, and therefore so the conviction was being quashed. I think that was a very big achievement in this.
Now if Madam is saying that there is some judgment, that may help, but ultimately problem is that the judgment will come when it will come to the court. The problem is that whenever either victim goes to the police station, they have no option to register offence. Or whenever, even if she doesn't go to our station, because of this she is admitted, for some reason admitted in a hospital and she discloses something, then again that. So, till this law is there, we are helpless. Yes, ma'am.
So I have a question regarding this itself. So what is your opinion on criminalizing marital rape? Because in today's law, we don't have any definition or anything which tells us the whole point of view or what the judiciary thinks about marital rape.
Oh, it's a very difficult question. It's a very difficult question. Now because of the same judgments on a personal liberty and integrity of body, and this is. But madam, still we are not reached to that stage to recognize marital rape. And the problem is now you are not come this side. And you see the 498A provisions is misused rampantly. And if you recognize this marital 498A, you know 498A of IPC, that is a cruelty, or you can take it as a more common domestic violence we call it. Like so that is rampantly misused. If you recognize a marital rape, the whole we don't know what will happen. We don't know what will happen. it will create some sort of, otherwise also this marriage, this institution of marriage is now, it's that. So, after a few days, I don't, it will be a very.
Since I'm practicing family law as well, there are many cases in regards to adultery, as in the respondent is in adultery and all. We have Joseph Shine's case, which has been a landmark judgment for most of the population, where Section 497 was decriminalized. So, do you? I would request if you can share your opinion in regards to that case, no? Because somewhere I feel the aggrieved spouse has nowhere to go. I also feel that since the criminal clause have just become too weak, or we can say that the act of adultery does not have sufficient teeth to bring justice to the aggrieved person. When it has turned into a civil ground for divorce, it is very difficult to prove adultery. That's number one, because we don't have cops helping us. Number two, when the aggrieved spouse goes around, finding the private detective, that then another petition comes up that there is a breach of my right to privacy. So what is your call on such situation? Because now agreement is getting more agreed. Apart from that, if I see, I had done one primary evidence survey in regards to what had been the impact where adultery was involved in among the spouse. The children of that family have actually got involved themselves into substance abuse, and not only that, they have also, there were instances of mental trauma, depression, and identity crisis. So, in that line, sir, can you please share your view in regards to Joseph Shine's case?
But now you have a judgment. Now we can't do anything. if it is now, and it's really difficult to do adultery in a territory of court. Because even if you go and file complaint for this offense, still it was, the judgments are there. I'm not telling you to what extent the court has gone. This the proof which is required for proving this it's really. So now we have a judgment. We can't say it cannot be proper for say something. Still you have a ground, as you said, that for a divorce. That is. You also share some share. This really not. They say that some sort of injustice is done by the.
So I have one question.
लेबर लॉ 2 मध्ये जे आता निर्णय शासन जे आता कायदे बदलले 10 नवीन कायदे समजा याच्यावरती कायदा लेबर लॉ 2 वरती आणलाय सेंट्रल गव्हर्नमेंटने. आता आपल्या इथे महाराष्ट्रामध्ये 29 वर्ष किंवा 10 वर्ष असे कर्मचारी काम करत आहेत. लेबर म्हणजे खालच्या न्यायालयातून लेबर लॉ म्हणजे खालच्या न्यायालयाकडून उच्च न्यायालयाकडे केसेस येतात, परंतु त्यांचे 10 वर्ष निर्णय आणि जातात. नागपूर खंडपीठाने जो निर्णय दिलेला आहे, उच्च न्यायालयाने श्रीकृष्ण आव्हानाचा निर्णय आहे, तरी कामगार कायद्यामध्ये त्याच्यामध्ये ते काही 10 वर्ष निर्णय होत नाही. आपल्या PWD विभाग आहेत, जलसंधारण, पाटबंधारे अशा 3 विभागात कामगार पाटबंधारे विभागात धरणावरती कामं करतात, इतर विभागात कामं करतात, परंतु त्यांचे जे निर्णय आहेत ते विभागांतर्गत तिथपर्यंत निर्णय दिले जात नाही त्यांच्याकडून, किंवा ते न्यायालयात पूर्तता होत नाही 10 वर्ष. तर त्यामध्ये निर्णय असे आहेत की त्यांचे कॅबिनेट निर्णयही झालेले आहेत, परंतु 2005च्या अगोदरचे झालेले आहेत. असे काही निर्णय आहेत. 18/2004ला निर्णय कॅबिनेट निर्णय झाले, परंतु त्याच्यानंतरही शासन 2 फेब्रुवारी 2024ला निर्णय काढतं की त्यांना पेन्शन द्या, जे बॅक टू डेट आहे त्यांना इफेक्ट दिला पाहिजे. परंतु ते निर्णय वित्त विभाग काढून सुद्धा आपल्या कोर्टामध्ये ते निर्णय अनियमित राहतात. असे अनेक कर्मचारी आहेत PW जलसंधारण पाटबंधारे विभागामध्ये. तर त्यांच्यावरती बॅक टू डेट किंवा पेन्शन आणि सेवा सुविधेचे फायदे मिळत नाहीत. तर त्या आता नवीन कायदा जो लेबर कायदा जो काढलेला आहे, लेबर 2 म्हणजे आपण आता शिकायला आहे, परंतु ते कायदे बदल झाले, त्याचे इफेक्ट ह्यांच्यावरती होणार आहेत का किंवा त्याचे परिणाम यांच्यावरती होणार का? त्यांना भरपाई मागच्या नियुक्ती दिनांकापासून मिळाली पाहिजे. कालेलकर अवॉर्ड आहे इथे 3 विभागांतर्गत, परंतु कालेलकर अवॉर्ड एक्सेप्टेड आहे का त्यांना? तर तो एक निर्णय आहे. कालेलकर अवॉर्ड असताना नियुक्ती कालेलकर अवॉर्डानुसार असताना सुद्धा विभाग किंवा न्यायालय तो निर्णय देतो. तर तो निर्णय एक त्या निर्णयाबद्दल मला मागच्या दिनांकापासून त्यांना नियुक्ती दिनांकापासून मिळेल का किंवा शासनाने नवीन धोरण अवलंबले त्याचा काय त्याच्यावरती इफेक्ट होईल का? तर ते तेवढंच मला पाहिजे.
कायदे कसं आता जे काही डिले बद्दल बोलतात आपण, डिले तर कसं आहे ते लेबर कोर्ट असो किंवा बाकी इतर कोर्ट असो, हे सर्वत्र डिले तर आहेच. त्यामुळे त्याला काहीच आपल्याला पर्याय नाही. म्हणजे पेंडन्सी एवढी आहे, जजेस कमी आहे, त्यामुळे हे जे काही डिलेच्या आणि तरी एक प्रयत्न हे जे काही लेबर कोर्ट स्पेशल ट्रायब्युनल्स आहे त्याच्या मागचा हेतू हाच होता की कुठेतरी ते एक्सपिडिशियसली ते डिसाईड व्हायला पाहिजे ते मॅटर्स. म्हणजे आता लेबरचे मॅटर्स आहेत ते एक्सपिडिशियसली डिसाईड व्हायला पाहिजे, म्हणून हे लेबर कोर्ट ट्रायब्युनल्स क्रिएट करण्यात आलं. पण ते पर्पज असं असे ट्रायब्युनल्स क्रिएट करून ते पर्पज सर्व होताना दिसत नाहीये. आणि आपलं जे काही म्हणणं आहे की काही आता नवीन कायदा आणला त्यामुळे काही ते जे काही जुन्या कायद्या अंतर्गत बेनिफिट मिळाला पाहिजे होते ते मिळणार की नाही, कारण की नवीन कायदा आला. नवीन कायदा कसा आहे की नवीन कायदा जोपर्यंत रिट्रॉस्पेक्टिव्हली तुम्हाला त्याला हे करत नाही, तर त्यावेळेसचे जे काही निर्णय असतील म्हणजे आपण कालेलकर अवॉर्ड म्हणतात त्या अवॉर्डच्या अंतर्गत आपल्याला जे काही बेनिफिट अक्रूज झालेले असतील ते आता काहीही निर्णय घेतला त्याच्यानी फरक काही पडणार नाही. त्याच्यानी काही विशेष कायदा कधीही प्रॉस्पेक्टिव्ह असतं. कायदा प्रॉस्पेक्टिव्ह असतं. तर त्या कायद्यातच तरतूद केली त्यांनी की तो जो अवॉर्ड आहे त्याला कुठेतरी ते त्याला नलिफाय करायची तरतूद असेल तरच ते शक्य आहे. तसं नसेल तर आता काही बदलही झाले असतील लेबर लॉज मध्ये तर त्याच्याने काही फरक पडणार नाही. त्यावेळेस जो कायदा होता त्या अवॉर्डच्या आधारे आपल्याला जर काही बेनिफिट्स आपण एंटायटल असतात ते भेटतील.
Sir, having the respect with B.R. Dove, just now retired, has delivered one justice regarding the reservation in reservation, some category, to 2024 up in August. And just before retirement, mentioned about the atrocity bail also. Given justice or you mentioned, I heard about news only. Regarding the bail in atrocity, in Maharashtra, Khairali atrocity case was there, and 1989 Atrocity Act is passed already, but conviction rate is also very low, and I'm mixing one another social issue. Reservation. 5 judges bench, 7 judges bench was there. Our Chief Justice also there. But during delivering justice order, Gawai, our Honorable Gawai sir, criminal, he raised very hardly criminal. But we are fighting for social cause and evils of so many socials. He himself, during that his tenure, he came first time in Mumbai. Protocol was not maintained. and shoe throwing issue was there. So whatever I am discussing, if you please focus on that. If you I will not answer in a the problem is that sub-classification judgment. Justice Gavin has also said that the judgment was criticized by people from his own community. But if I ask my personal view, that judgment is right. That judgment is not, that is, we have to understand the intent behind reservation. If the situation when this concept of reservation was introduced in the Constitution, certain caste or tribe, bring them in a mainstream. Now what is happening because of now if from a particular category, Justice Gavi has also said that if a son of IS officers says that I need reservation, so that may not be right, because you now you don't need, you can compete with other general category students, or you can compete in employment or with others. At that time, we were not, because of the social backgrounds, or we were discriminated. We were not getting good education. We were not allowed to in schools. And in that situation, that concept of reservation was there. And now, if you after everything you have now, and still you say that, no, I still want that. Suppose now I'm a High Court judge and I'm saying that for my son I want reservation. And who goes to the good school, who has every facility with it. And still if I say that, and it's not a some state that the judgment has put some rider. It's not that absolute judgment that you can do it. It says that you identify the caste. You identify the caste within a scheduled caste or scheduled tribe who are still not benefited by these reservations. They have not said that you do it blindly. There are certain castes, still there are certain castes within a scheduled caste or scheduled tribe. They are still backward. They are still backward. So the intent was to bring those castes in that category in a mainstream. You see what happens in a case in a scheduled tribe. If you see these medical admissions, you don't get candidates or students from a scheduled tribe category. Still, you don't get it. And what is happening because of that? Those who are not a scheduled tribe, lots of petitions are filed. Where in the caste validity when this caste is invalidated, caste certificate is invalidated of a scheduled tribe candidate, and they come to the court. Oh, now I have completed my MBBS course. Now I have put in this much of service. So please protect me. Earlier that was done, and the court has protected the services of not many persons, saying that now there is no point. If his caste is invalidated and he is not allowed to practice now, that ultimately the state has invested. So not many cases are there. So in my personal view, that now we have, because of that benefit of that reservation or some
now we have achieved that position that your sons can compete with others. It's not that now maybe still we have not come to that state, but still it's not now open, and that is not. No school can deny you admission on the ground that you belong to this category or you belong to this. And if your son is taking education in a good school, if your son is having all facilities which are, so in that context that judgment is delivered, and it says that those castes who are there in the scheduled caste and scheduled tribe, they have not what benefit of this reservation. They still need this. So instead of giving this benefit to those castes who are now come in a mainstream, please give them that reservation so that they can also come in a mainstream. That is the intent behind that judgment. So that is
to give justice, some analysis or evidence will be from there. On that evidences, justice will be delivered. But caste census, which caste is remaining behind, which caste brought the benefit. Survey, proper survey should be done. Government of India survey should be done.
Neither is there in the judgment that you have to come some empirical data. On that basis, only after identifying that you have that data, then only you can do it. That is the right of doing that.
Already 3 more states started, sir. Executive already started for implementation. Maharashtra is waiting without proper any analysis or any survey.
They can't do it. They do it with the charity. They can't do it without empirical data. They can't do it.
But most state already, sir.
But that is what I am saying. That a personal view. That judgment was really severely criticized. That is my personal view. There is nothing.
It might be just to stop you wherein this thing needs to be highlighted from your end. If he has correctly said that those who have got the reservation, next generation should not get it. Is it right which is said?
No, that is not. That if you got reservation, it that is not.
Okay.
It's not say that
So,
it is not.
now when it is coming up,
Simply he has mentioned cadre, IPS, IS, judges. He has mentioned only cadres. But suppose first generation is the judge. Suppose I am judge. My son is not good for study, and I am retired. I am getting pension. My son's son should get or not. He is also eligible, but he has got actually criminal concept of service.
yes.
2000 that OBC Button Commission, and in that case they never mention about SCST, sir. That bench was more than 13 or 13. In that case, they mix the promotion case only, SCST promotion case. Mix. Okay, but criminal concept, if you are implementing for SCST also, so society, if they won't permit, in legislative also they won't permit. Modi has cleared 100 MP went to him and asked about the remark. There was not judgment, only he made remarks. Judgment is different, but affecting so many MPs went to Prime Minister. And he clarified, judgment is okay, but criminal here will not be there. But anti-reservation people are making propaganda of this judgment, and they are making anti-reservation policy and all the things. That's why the judgment, atrocity about he mentioned before retirement, about bails. Some news I had. But deliver justice or judgment or I don't know. But he mentioned bail should not be given.
Bail will not be provided. Atrocity. Is this one something which is
कायद्याचा गैरवापर होत आहे. स्त्रियांनी गैरवापर करत आहेत आणि पुरुषही गैरवापर करत आहेत. पण स्त्रियांना कायद्याकडून खूप जास्तपणे म्हणजे जास्त म्हणजे एक बोलू शकतो की आपण थोडी लिबर्टी जास्त आहे असं बोलू शकतो, पण पुरुषांना कमी आहे. मग तिथे त्यामुळे पुरुषांवर म्हणजे कायद्याचा गैरवापर या स्त्रिया जास्त करत आहेत आत्ताच्या शतकामध्ये, म्हणजे ह्या जनरेशनमध्ये. तर मग पुरुषांसाठी असे कायदे आहे होतील का पुढे?
परिस्थिती असते फार आलेली नाही.
One last question for the day.
Yeah.
So many questions now.
Good morning, sir. Just wanted to highlight before going to the question that Supreme Court recently highlighted that the person practicing law should be smiling and should have a good sense of humor. And since morning, the session started, I have been observing that you have been quietly and with a very smiling face during your opinion. So that's a very good morning for all of us. That being a high court judge, you've been giving your insight with a very smiling face. Thank you for that. And coming to the question, you said that the Chief Justice of India actually gave the judgment for the bulldozer justice, and I guess that was the reaction that he encountered with, because I read the articles. So I just wanted to ask, when you pass judgments like this, which has a larger implications, so do you take the opinion of a larger public? What is the social media buzz like? The trend is like, we are in 2025 and everyone has an opinion, and the opinion is very strong. They have their own reasoning behind it. So you as a judge, do you take into account the opinion of the larger public?
See, all the judgments are for society. All the judgments are for society. So you can't pass judgments without taking divorce the opinion of society. But its judiciary exists for society. The judiciary exists for people. They don't pass judgment for themselves. They deliver judgments for the people. So social media misal, you can't ignore society or society's opinion when you are delivering justice. That is always. No. If it's a society's interest, you don't have to think of consequences. Think of consequences what will happen. If it's an interest of the society, then you know act accordingly.
मला तुमचा अनुभव ऐकायला आवडेल. ॲज अ जस्टिस आणि तुमचा काय म्हणजे अनुभव आहे आतापर्यंत?
कशाबद्दल जाणून म्हणजे मला ते लक्षात आलं.
पोलिसांना एक भार आहे आणि नवीन मुंबई हायकोर्टमध्ये आहात ॲज अ जस्टिस, त्याबद्दल तुमचा अनुभव ऐकायला आवडेल.
त्या संदर्भात एक प्रश्न आहे सर, इथंच पुढचा एक प्रश्न आहे. असं म्हटलं जातं की जजेस हे सिंहासारखं असतात, पण सिंहासनाच्या खाली असतात. हे किती खरं आहे?
We have our own limitations. Yes. And just because we are judge and some powers are conferred upon us, we can't do this. We have our own limitations. So, listen, I don't know who has coined this Siyasati Astan and Siyasanata Khali Astan. I'm really glad to know about this, but it's not that. It's not that. You have various compulsions. Sometimes necessary not to take while delivering judgment, while deciding some matters, to take lot of considerations where